dream I know deep up my feelings for you. Watch.
Hello reality viewers, welcome back again to Reality Latest Gist, the home of news and politics. For this channel, we dey drop news every day and we dey react to every videos wey comes our way. And na reality news na we dey drop for this channel, and we dey also dey talk am as e be. If today na the first time wey be say you dey come across this channel, you are highly welcome. Thank you so much for stopping by. And if you are returning subscribers, I appreciate all of una for una massive support to this channel. I say may God bless all of una in Jesus name. Amen. I get video wey I want present to una this very moment, and I go dey follow una dey watch the video. After we don watch am together, make we drop our opinion constructively for the comment section. Like our videos and also share our videos if possible. Bye for now.
It's happening in the U.S. District Court. U.S. District Court is like what we call high courts. You know, it's a national court. It's like a federal high court or something of that nature. You know, it's more or less a referendum in our own judicial system. Far away in America, article is pressing. According to what the court says, according to court document, the court established that it has jurisdiction over the matter under U.S. law, which authorizes any interested person to request that a U.S. District Court order the discovery of documents and testimonies for use in a foreign proceeding, that is a foreign court, from persons who reside or are found within its district. So the court is trying to say, Atiku met all requirements. He's an interested person and he needs this document because of a case that is pending in another country. So there is no reason why they wouldn't give it to him. But the challenge here, not to Atiku though, the challenge is to APC and their candidates is that, number one, they said in their final address that they have submitted the academic record of their candidates. Okay, if as a law firm or if as lawyers you requested that academic record and they gave it to you, why wouldn't they give it to another person? And as I said yesterday, they have even shot themselves in the leg by using their mouths to say that they submitted the academic record. Because what it means now is that Atiku is boldly trying to say, I don't believe that what you people submitted is true. That is why I need a counter proof to be sure. Because already there is something you people are parading. That is the certificate from the university that carries 3 signatures. And my witness, my star witness, Mike Enahoro Eba, that was deposed and cross-examined during the trial, says that what you people submitted in the Form EC9 is not the truth. And I think there were some, if we go back to what really happened since November last year, you will appreciate where this whole thing started. I don't know if we have those slides, something around November last year. So you notice that in November last year, this Mr. Mike Enahoro Eba sued then candidate Tinubu over alleged certificate for forgery, age falsification, the one that started in November last year, I think. Certificate forgery, age falsification, and lying under oath. Now, in that it says here, he alleged in his complaint that Mr. Tinubu submitted an affidavit of personal particulars to INEC in June 2022 as part of a required filing to run for president, which included an alleged forged Chicago State University diploma dated June 22, 1979, and other information inconsistent with the Chicago State University document. Mr. Enahoro stated that after Mr. Tinubu made his INEC filing, Mr. Enahoroeba obtained a subpoena. Now, listen, this is very, very, very important. So he obtained a subpoena from the Circuit Court of Cook County, dated 11th August 2022, and served it on Chicago State University, according to paper filed by Atiku in the U.S. court on August 2, 2023, to substantiate his accusation. Now, listen, this is important. Remember, according to what you said here now, that the APC and their candidate are in US trying to say that that Atiku is prying into the privacy of their client, that Chicago State University should not release the documents. So the question is, why did Chicago State University release the documents to Enahoroeba last year? If it is against the law, why did they release it? Where did he get it from? And now you may be saying, why, if the document is in the open view, why is Atiku going there again? I've tried to explain it here. It's a very simple thing. These people have come to say they have a document that is the academic record of their candidate, which is contrary to what Mike Enahoroeba obtained from the same university. So we have two documents currently now flying in the face of the judges. Am I right? We have the one that Atiku's witness obtained according to our Evidence Act. That document that is with the judiciary now, after the hearing, is perfect, because he didn't just pluck it from the tree. You can see that as I was reading, I think, okay, I don't think I have that one. It says, the one that says in an affidavit, okay, there is a statement here by going to get subpoena. Now, I have another file here that says, in response to the subpoena, Chicago State University registrar, in respect to this subpoena that Enahoroeba obtained last year, the Chicago State University registrar, Mr. Caleb Westberg, wrote to Mr. Enahoroeba's lawyer. Mr. Enahoroeba's lawyer in US name is Matthew J. Cowles, on September 22, 2022, informing Mr. Cowles that the enclosed document is all the record we have for Bola A. Tinubu. So it means that the process Enahoroeba took to obtain that document is legal, is acceptable in our own Evidence Act as something that can be tendered. So I want us to know this thing really well, that for the fact that Atiku themselves did not bring it, according to APC's lawyer saying, oh, they did not bring anything. No, they brought it by bringing Enahoroeba as a witness, and he testified under oath. So it is incumbent on the judges to treat it as a real evidence. Now, the APC and their team submitted another set of documents saying is the university record. I am sure that for them to go and bring another document, they can't bring exactly what Enahoroeba brought. They're going to bring something that is disjointed. And that is why Atiku has now gone to say, okay, Enahoroeba, my witness, has a document. These people have a document. Let us now bring the final and the third document from this university that will break the tie. If what this university gives me is equal to what APC and their candidates submit, then it means that Enahoroeba's own is wrong and he has lied under oath. But if what this university gives me is equal to what Enahoroeba submitted in evidence under oath, it means that APC and their candidate, they lied under oath. We don't know where they got their own certificate. Does that make sense? And what is the meat of the whole matter? The meat of the whole matter is that there are discrepancies between what was submitted to INEC and what the university produced. The dates of what was submitted to INEC showed that somebody was born 1954, whereas the date of the one that was produced by the Chicago State University says that somebody was born in 1952. So there is a discrepancy in dates here. Secondly, the certificate that was submitted to the INEC had 3 signatures, whereas the certificate that Chicago State University gave had 2 signatures. And remember that we are talking about the photocopy that was given by the university. How can you photocopy a document and all of a sudden extra signature will enter? Thirdly, the logo on the one submitted to INEC is different from the logo on the one that the university produced. And even another information here is that the 3 people that were alleged to have signed the signature that was submitted to INEC only started signing certificates around 1990s. Whereas the certificate that was submitted were meant to have been signed in 1979. So Nigerians, no bad feelings. It is good and it is important that this thing is sorted out. Let the president clear himself if people are cooking up and ganging up and lying about him. In fact, every supporter of the president should be advocating for this university to release this document so that he can clear his name. It will not be nice for you to be supporting someone and something is hanging around his neck and there is an opportunity for the person to clear his name and you're blocking it. That is for social reason. But for legal reason, if indeed what Enahoro Eba claims is anything to go by, then APC did not have any candidates during the election. And all the votes allocated to them by INEC will become a wasted vote. That is the meat of the matter. So the question, Nigerian, is, should we not follow this thing through to be sure that maybe an innocent man, people who hate him, are just cooking up lies against him? Or Nigerians are screaming that injustice is being put in their face and nobody cares to know. We don't know which is which. And this document being given to Atiku will solve the question. And people might say, but the trial is completed. Of what use would that be? It is very, 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 very vital. Because they submitted a set of documents. They themselves submitted a set of documents claiming it's from the university. That gave even the opportunity that Atiku did not beg to fall on his laps for him to now go and get the one he feels is authentic to counter it at the Supreme Court. It means that this Pandora box will be slugged out at the Supreme Court. So it is not a fight in futility. It is a very strong fight. And the soul of Nigeria is at stake. Nigeria has never had it this way before. And I just hope that it will turn out well for all of us. So that is why I think that someone is standing somewhere on a shaky ground. Because if I am President Tinubu, if indeed Enahoro Eba lied with my name, and all this thing has been flying since last year till now, I will sue him and sue him and sue him and make such claims that 10 generations after him will not end up paying. But if indeed Enahoro Eba has been telling us the truth, please, Mr. President, you know that if it is true, you don't deserve to be in the office. Just carry your bag and go because you did not fulfill the requirement of the law. I don't know who is saying the truth now, but one of them must be saying the truth. It's either the president has been innocent all this while and people are ganging up against him, or what people have been saying since 1993 till date, 30 years, is truth. And you know that every lie has expiry date. We don't know if the expiry date of a lie is 30 years after, or the gang up against one man for the 30 years will then be laid to rest. The judges, the court must not use another technicality to knock it out. The whole reason why this thing is still re-emerging is because in 1993, they used technicality. In 1999, please, they used technicality to knock it out. They used technicality to tell us that it is the duty of the House of Assembly. Oh, you cannot charge this person to court now because he's now under immunity. So the Supreme Court used technicality to do what? To allow this gangrene of a wound to be festering until now. Let's deal with this thing now once and for all. Let the person who is guilty serve his term. If it is a Nahoroeba, an Atiku, let them be shamed and be exposed. If it is what they claim, let the person serve the consequence. That is my opinion.
For me, like I said initially, Atiku has really taken a very bold step, despite the fact that they've concluded submitting their evidence, calling their witnesses and all that, but he still went to the United States, to ask that the University of Chicago release his academic record, that he wants to see it, because the person that came to court on a subpoena brought something different from what the counsels to Tinubu submitted. So there's a lot of confusion. So Atiku wanted to clear that confusion, and that's why he went this far. So before I bring in, just listen to this clip. There was this clip from Symphony that relates to the topic we are discussing tonight. Let me just play it and then we come back.
Section 131 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, read thus: a person shall be qualified for election to the office of the President if A. he is a citizen of Nigeria by birth, B. he has attained the age of 40 years, C. he is a member of a political party and is sponsored by that political party, and D. he has been educated up to at least school certificate level or its equivalent. According to this section of the Nigerian Constitution, Bola Ahmed Tinubu qualifies to be President of Nigeria on the grounds of birth because he was born in Nigeria. He also qualifies to be President because he is above the prescribed 40 years of age. His being sponsored by the All Progressives Congress APC also meant he is qualified. But did he meet the provision of the last section of the Constitution, which says he must be educated up to at least a school certificate or its equivalent? In 1999, when Tinubu contested election for the office of Governor of Lagos State, he made the positions an oath to the effect that he graduated from Government College of Ibadan in Oyo State. A few months into his administration of Lagos State, the news broke that Tinubu had forged both his age and academic records. A petition signed by the duo of Alhaji Jamid Serki and Dr. Waliu Balogun Smith, dated August 12, 1999, accused him of lying on oath over his age and academic records. The petitioners alleged that Tinubu's claims in INEC Form CF-001 that he attended Government College Ibadan and another claim that he attended Chicago State University were all false. However, the two fell on the Lagos State House of Assembly to investigate the claims. The House looked the other way because all its members were of the same political party. In an investigative report by the news magazine, Tinubu's claim of having attended St. Paul's School, Aroloya, was found to be false, as the school did not exist as at the date Tinubu claimed he attended it. The news magazine would later find out that his name was not on the register of Government College Ibadan as at the date he claimed. The magazine also punctured Bola Tinubu's other educational claims. The news magazine was at the time published by Bayo Ononuga, one of Tinubu's ardent lapdogs today. One would ask, what happened? Disturbed by these developments, Chief Gani Fahimi approached the Federal High Court and sought an order to compel the Nigeria police to investigate the allegations of forgery against Tinubu and prosecute him if found to have made false claims on oath. Chief Fahimi was represented in the matter by Ebun Olu Adigburua, now a senior advocate of Nigeria, SAN, while Tinubu was then represented by Professor Yemi Oshibajo, SAN, who at the time was the Attorney General of Lagos State and Commissioner for Justice. The Nigeria Police was represented by Sunday Hindero, Commissioner of Police in charge of legal. They all appeared and argued the matter before Justice Sunday Wilson Egbo, who upheld the argument that Tinubu could not be investigated because he was protected by Section 308 of the Constitution. Not satisfied, Fahimi took the challenge up to the Supreme Court, which dismissed the case on technical grounds. Soon after the matter, Justice Egbo was fired by the National Judicial Council (NJC). However, Tinubu had a miraculous turnaround when filing his INEC nomination forms for re-election in 2003. In the same INEC form CF001, where only 4 years earlier he made claims to academic attainment, including Government College Ibadan, where he claimed to have gotten his school certificate, Tinubu, like a chameleon, changed. He entered an A in all the columns requesting his academic qualifications. Earlier in 1999, Senator Bola Tinubu had claimed to have attended St. Paul's School and Government College Ibadan, but by 2003, he entered an A on the column for his primary school and secondary school attainment. According to the interpretation of abbreviations, NA could either mean not available, not applicable, not assessed, or no answer. All these were from a Tinubu who, while defending the Fahimi legal challenge, claimed that his academic records got lost while in exile. This is beside the allegation that the NYSC certificate presented by Bola Ahmed Tinubu to INEC as part of the documents necessary for his clearance to contest for the prime office does not belong to him. According to a publication in Premium Times, the certificate presented by Tinubu to INEC bore the name Tinubu Bola Adekunle, indicating that it also may have been forged. Information gathered from those who have details of Tinubu's records revealed that the document showing the differences in name came under scrutiny by the Presidential Petitions Election Court. Judges of the court, Symphony News was told, had difficulties reconciling Bola Ahmed Tinubu as contained in his INEC form CF001 and Tinubu Bola Adekunle. Both names are glaringly not the same. Even Tinubu's lead counsel, Wole Olanipekun SAN, could not find arguments to defend the differences as Ahmed and Adekunle are different names. Questions about Tinubu's eligibility to contest the 2023 presidential election on account of his academic records and allegations of perjury will never go away. And as Simon Kolawole of the Cable.ng said in his article titled Tinubu's Lingering Certificate Conundrum, Tinubu must be prepared to answer questions around the omissions. This is one of the many reasons all Nigerian eyes are now glued to the judiciary. Will the court amend the Nigerian constitution by upholding Tinubu's qualification to contest for office, despite the provision of Section 131D?
And like you've heard from this clip, that the current president of Nigeria has got so many questions to answer. So, Doc, please just come in, break down this clip that we've just watched.
I am happy for that clip. Just before you play the clip, I was saying, let the judiciary deal with this situation once and for all. You saw how technicality buried this case since 2003. Saw how technicality buried it. It buried it, but it didn't kill it. It has wriggled its ugly head again. And it will be Okay, let me put it this way. I still believe and I know that no matter what you claim, if you don't tender it appropriately to the court, it may not be given value. I have taken time. The latest Evidence Act, the word Evidence Act is guideline on how to tender evidence that will be admissible in Nigerian courts. The latest one was Evidence Act 2011. If you go online, you find it. I have read it from page 1 to page end, especially the sections that bordered on all these things. And I can comfortably tell you that they are written in English. They are written in English. That the path that Atiku has followed so far in the issue of this academic record is substantive. It is acceptable. It is admissible. He did not tender it. He prayed it in his prayer. In his petition that he submitted in March, he said that APC candidate did not qualify for the election as at the day of election because he submitted false academic record. Go and read the petition. It is now time to tender evidence. He did not tender it, but he had a witness that was put in the witness box, who swore under oath and who submitted that document. Now the question is, that document he submitted, the name of that person is Mike Enahoroeba. The question is, that document he submitted, is it cogent? Is it admissible? Does our Evidence Act support it? Yes, because he did not pick it from the street. He did not write it himself. He followed legal process. He went and hired a lawyer in the US jurisdiction. And the lawyer issued a subpoena through a court of competent jurisdiction in the US. That court issued a subpoena to the registrar of Chicago State University, mandating them to release that document. They released it to the law firm that was representing Mike. And that is how it became a document that Mike had a legible, a legal, and acceptable access to. And willfully, he was subpoenaed by Atiku's lawyer. When a subpoena is issued to you, you don't have a choice. You don't say, no, I have this thing, but I don't want to produce it. A subpoena means there is something you have that will help this court make its decision, and you must produce it. So whether Enahoroebala liked it or not, he came. And when they asked him during the cross-examination, he said yes, that he is an LP member. He's not a supporter of Atiku. He said he voted P2B, he voted Labour Party, but that he's interested in making sure that Nigeria is a rightful place because he himself had gone to court in Abuja. He went to court in Abuja. I think we have the slide of his going to court in Abuja. He went to court in Abuja, and the Abuja court said that he does not have locus standi because he's not a party, he's not an APC member. Now, he's not an APC member. No, yes. Okay. Just keep going. Yes. The third paragraph says he initiated proceeding against Mr. Tinubu by filing a direct criminal complaint in the Chief Magistrate Court of the Federal Capital Territory. I don't know if this is the last one that you have there. So that was last year. But the court did not give time to it, saying that he does not have any locus standi because he's not an APC member. But he did not do it as if he's coming to say, oh, this person is not qualified. He said it's a criminal complaint against someone. So that document is now with the court. because Atiku's lawyer issued a subpoena to him, and he came under subpoena to testify. By his testimony and his written testimony, that particular document was rightfully admitted by the Presidential Election Petitions Court. It's part of the document that is now on the desk of the Presidential Election Petitions judges. And that document he submitted brought a whole lot of discrepancies with respect to the one that was submitted by APC's candidate. The age that is on the document is different from what the university issued, as I've mentioned. In fact, even though in 2003, he was saying not applicable when it comes to the secondary school, but there is a secondary school certificate that was submitted to a college certificate that was submitted to the Chicago State University before their admission was gained. And that is where the challenge started, because the gender of that person is a female. The names are the same except A, which is written in initial, and it is this A that has been causing problem. Now, as we can see here, the certificate of NYSC discharge certificate presented to INEC bears Adekunle. Is it possible that an Ahmed went to college and went to university as Ahmed and came out and served as Adekunle and reverted back again to Ahmed? We don't know. We do not know. It is now left for the courts to tell us how this thing is straightforward. If the Supreme Court of Nigeria denied David Loin his governorship seat in Bayelsa State because his vice president has inconsistency in his name, what will they do this time around? If our Supreme Court and our appeal court had used their mouth to say that a forgery might occur in two ways. One way is when you forge a document that is not existing at all. That is one way a forgery can be made. The other way is to forge a document by modifying an existing document. That is, if someone steals my NYSC certificate, and instead of writing Chukwu Agozie, the person decides to write Chukwu Gozie, is a forgery. And if NYSC mistakenly writes my name is Chukwu Gozie, and I feel like I don't have time to go and worry them, I went and used myself to add A Agozie. That A that I added has made it forgery. So the certificate exists. NYSC, I was mobilized. My name is on the record. However, the one they gave to me, remember, if you did NYSC in Nigeria, on the day you're collecting your certificate, you will write original copy collected by me. So they have a photocopy. I don't know. I did it. They have a photocopy. If I lose my NYSC certificate today, NYSC will not issue me a new one. If I go back to them, they will give me certified true copy of that photocopy that I left with them. They'll put their stamp and say, the original is lost, but this can be accepted. It's called certified true copy. Which means the certified true copy of the certificate that is on the record of Chicago State University is what should be submitted to INEC. But what was submitted to INEC is an entirely different certificate that has a different logo and 3 signatures. If our court wants to accept it, we are waiting, we are watching. Our eyes on judiciary. The last tweet by the man who was saying that this certificate issue need to be trashed, he summed it up by saying this thing has dragged. Will our judges amend our constitution to clear one person? Will the judges destroy our constitution just to accommodate the interest of one man? Or will they say that Nigeria is bigger than one man and stand? As per forgery, the case of forgery is perfectly established. I have always worried, what technicality will the court rely on? I have looked at the Evidence Act in and out, and I think Atiku is striking the right chord. And just as Enahoreba went there to testify on behalf of Atiku, even though he voted for P2B, he knew what he was doing. He knew that if Atiku wins in that prayer, that it is P2B that will reap the fruit thereof. So, it's all good.
So if you dey right, una still leave una comment below. If you dey bad, una still leave una comment below. Una remember say everybody gets freedom of speech. Okay? All right. Thank you very much.